Hello and welcome. My name is Patty Murray and I will be your host and moderator for today's peer-to-peer webinar presented by FamilyKind, a nonprofit organization that empowers children, parents, and couples before, during, and after separation or divorce. We are able to bring you this webinar series for professionals free of charge because of the generosity of our two sponsors, SoberLink and Our Family Wizard. SoberLink supports accountability for sobriety and child safety, combining a breathalyzer with facial recognition and wireless connectivity for real-time results and reports. SoberLink's new Family Assistance Program offers alcohol monitoring free of charge to anyone who qualifies. By increasing our total reach in our mission of supporting families affected by alcohol abuse, this program will help continue to reduce litigation and foster peace of mind. Our Family Wizard is a comprehensive app that enables you to conduct all your co-parenting communication on a single platform. Powerful tools document your parenting time, reimbursement requests, payments, exchanges, and more. This means less conflict and more energy to focus on your children. Today's webinar is entitled Mediation Review and Consulting Attorneys, What It Means to Be One and How to Work with One. We are going to learn from two professionals who have their own practices and are FamilyKind mediators. Joe Brody is a family and divorce mediator and collaborative attorney in New York City and Westchester. Joe is a member of the matrimonial mediation rosters for the Supreme Courts in Westchester and New York counties, and is proud to offer volunteer sliding scale services with FamilyKind. Joe received her JD from NYU School of Law and her BA from the University of Michigan. Catherine Canade is a collaborative attorney and family and divorce mediator in private practice in Brooklyn and on Long Island, who also serves as a consulting and review attorney. For FamilyKind, Catherine is a child-inclusive mediator, a Good Talk for Parents facilitator, and a parent education teacher. She received her BA from Vassar College and her JD from the Washington College of Law at American University. Also joining us, as always, is Leslie Friedland, Executive Director of FamilyKind, who will add her insights in from time to time. Two housekeeping notes. Today we are starting our expanded format to 45 minutes so we can answer more of your questions. Please feel free to send in your questions using the chat feature and we will address your questions during a Q&A session at the end. Now it is my great pleasure to turn things over to Joe and Catherine.
Thank you, Patty. So as Patty said, Catherine and I both work as mediators and consulting and review attorneys and offer our services with FamilyKind. So we're happy to be here to share what we do in our private practice and what we do when we work with FamilyKind.
Yeah, Joe and I have been colleagues for almost 10 years now. We've worked together on many cases, and we've also served on the board of directors for the Family and Divorce Mediation Council of Greater New York. So it's great to be here. Thank you for having us.
Yeah, and we've learned a lot from each other, and I see other faces on here that have mentored me, and so this peer-to-peer is meant to be that, just a conversation among peers, sharing information. So I'm grateful for Catherine for being that for me and to all of you as well.
And
I'm sorry, Leslie.
Started, I just want to thank you, Joe and Catherine, for presenting today. You've put a tremendous amount of work into it. I think this topic is extremely important, and I love the fact that you're coming at it, from different perspectives. So I just want to extend my gratitude to you and Patty for working on this, and excited to be here. Thank you.
Thank you, Leslie. So today we're going to talk about best practices when working as review and consulting attorneys in the mediation process. And then we're going to turn it on its head and talk about it sitting in the mediator seat, how best to use review and consulting attorneys as the mediator.
So we thought we should start out with some brief definitions because we may have some people on this webinar who are less familiar with the terms we're using. So when we say review attorney, that we're working as a review attorney, It means we have been hired by a client to review a separation or settlement agreement that has been drafted by the attorney mediator or by a scribing attorney, someone who works with a non-attorney mediator to write up the agreement on behalf of the clients. In those two cases, we're just there to review the document. As a consulting attorney, on the other hand, we're going to come in either before they've even started mediation or somewhere throughout the process. Sometimes it's after first or second session, sometimes when things have come up that they just don't understand. And that takes us all the way up to the review portion again, where we would start out as consulting and then we turn into review, because we, in all likelihood, we're going to also review the separation or settlement agreement on their behalf.
Right, and throughout this presentation, we're going to use the word consulting attorney kind of broadly, unless we need to make a distinction between review and consulting. But consulting attorney or attorney is probably the term we're going to use. So what is an attorney's role in a mediation process? Well, we should start out that we're an attorney. We're an officer of the court. We shouldn't forget that. And our behavior is governed by the New York Rules of Professional Conduct, which I just reread. Hadn't read that in a long time. And yes, we are doing that without even knowing it. We are educating our clients on the law and how it would apply to their specific situation. We are coaching our clients with communication. They're not always able to articulate their needs and interests. Sometimes they get in their own way. We can be a great coach for them. We can brainstorm options. If things aren't coming up in the mediation process, we can do that with them. Reality test. I just lost my PowerPoint, hold on. Excuse me. How is this going to work for you?
So Joe,
Yes.
I'll need you to share your screen again.
Yeah, thank you. I've kind of gotten...
And then go to your PowerPoint. There you go.
That was unusual with all the practice. Okay. Thanks, Patty. We were reality testing, I think, when I got dropped off. How is this going to work? You know, sometimes they're so caught up they don't realize you're not going to be able to afford that. And of course, we're going to review the agreement. Does the client understand the legalese? It's written very complicated. We can explain it to them in plain speak. We offer an extra layer of protection, which we're going to talk about later on as well from the mediator point of view, but a review draft is always a better draft for when, if it's ever challenged later on. And lastly, be mindful of your tone. You don't want to come in aggressive. You are supporting from the sidelines a mediation process. It's a gentle advocacy.
Yeah, I mean, the tone really matters, and we need to kind of let go of any kind of aggressive tone we might use and say it in a way that can be heard, similar to when we're coaching a client on how to use their tone properly. We also want to kind of model that same kind of gentler tone than we would use in a more traditional process. So now we're going to talk about best practices for consulting and review attorneys. I hesitate to use the word best practices. This is our, Joe and my practice. So we don't want to say that ours are the best. It's some of the practices we've developed over the many years we've been working now. So one thing, of course, is continued education. You need to keep up with your CLEs and learning the relevant areas of law so you can advise your client with confidence. If you don't know something, however, we need to know what we don't know. For example, maybe it's a trust and estates matter or a special needs child, or there's some reason why we might not have particular expertise and we might want to refer them out. And of course, we don't give tax advice. And so we would always say you need to consult with your CPA or your financial advisor. We need to know what we don't know. And we ask a lot of questions to determine that. We want to make sure, that there was no duress, pressure, or power imbalance. Was one person very, very knowledgeable about finances and the other person wasn't? So we need to help, kind of bring up that knowledge deficit if there were. Were they confident enough to speak their mind? Some people come to us because they want the confidence that can come from speaking to someone. So when they go back into the mediation room, they feel more comfortable speaking up for what they really feel, what their needs and interests are. We want to be sure, again, what they're agreeing to. Are they understanding what they're agreeing? Sometimes I'll say, did that come up in mediation? Did you even talk about that? And they may say, oh, actually, I don't remember. I'm not sure. What does that really mean? So it is very, very useful to go over things that even if it's already agreed, you want to go over the agreements and make sure that they understand that. And, any concerns about how the agreement was reached, sometimes the mediation could feel rushed to them. When I say, how did this go? They'll say, you know what, this part really went over my head, but I agreed to it because I wanted to keep things moving. And actually, I didn't follow that, but I was afraid to speak up because my spouse was there. So I think when we talk to them privately, we can hear a little bit more about the process and see if the mediation process was all it could be, or when they go back in, they can improve it by them speaking up. Then, the reality testing, we talked about this a little bit before. We want to make sure that the client is going to be able to take care of themselves and their children. Can they really do the parenting schedule that they've agreed to? Does it work with their work hours? And if it doesn't, then we have to talk to them about how they would say it. How would they say that there's certain tweaks that need to be made, or I'd like to revisit this topic. We have them frame it in a way that they propose a change, or we'd like to have further discussion, not that they're demanding it or they're saying it in a way that their spouse really can't hear it. And, the last question about sufficient disclosure and waivers, it's very important that the clients understand that there must be full financial disclosure. We cannot make them disclose, just like the mediator cannot make them disclose, but it's something to really encourage. If you have a client who's not sufficiently disclosing, you can do a great service to the process by encouraging them and say, everything has to be out on the table, and then it's up to the two of you to decide what to do about it. But if you don't have the information on the other side, you can't have a valid waiver. I always say to my clients, we need an informed waiver, informed consent. So we need to put out the information, and we need to know what it is we're giving up if we are going to be giving something up. And sometimes for the client, that's really eye-opening, and they hadn't really thought about it. So when we're consulting in mediation, we ourselves have to be mediation friendly. And so we ask them, why did you come to this decision? Maybe it's something that we ourselves would not have advised them to do had we come in earlier, but they've already made that agreement. And so instead of saying, you could do better, or this or that, we don't want to disrupt the mediation process. We're there to support the mediation process. And we can say, why did you come to that decision? What was it about it? And oftentimes that makes sense. And we can use our mediation skills of reflective listening. We hear the client. We reflect what we've heard so that they feel heard and validated from us. And we can reframe things. Sometimes they want to say things in a certain way. And I might say, let's call it this. Let's use a more positive way of changing the language between ourselves. And then they pick up on that, and they can use that language with their spouse, either privately or in the mediation. So I think it can be helpful.
I'm sorry.
Yeah.
Catherine, and we had two examples of why the why matters.
Yeah, so I know you want to say your example first.
I can, if you want me to.
Sure.
So I had a situation I was consulting, and it was the father. He was clearly, the husband was giving too much maintenance in terms of the guidelines, what the guidelines would do. like substantially over. So I was curious and I asked why. And he told me why. And it was very important to him that his family, his wife and children, could stay in the house and afford the mortgage. And without this amount of money that was agreed to in mediation, they would not be able to do that. Great. Done.
Right. That's a great example. Another one might be on a parenting plan. I had a situation where the father had substantially less than half the time, and he seemed very happy to have less than half the time. And I just asked him, why is that? How did you come up with this agreement? And it turns out he's in recovery, and he made some errors in judgment while he was drinking. And so the parents have decided to start off slower. So he's going to start out slowly, build the trust again of the co-parent, and then move up toward a more balanced, equal parenting time later on. So again, that made sense, but without asking the why, we wouldn't have understood.
Right. So it's getting to the interests in our mediation training. What not to do. And I know I've learned from mistakes. Coming in with a big ego. Not really wise, because you're not the center here. You want to work from the sidelines. You want to support. You don't want to rewrite the agreement to fit your template. And I'm looking at someone now on the screen that was a mediator in this situation, and thank goodness she was confident and experienced and was able to say, does this work for your client? And I was the other consulting attorney. I was a consulting attorney that was not rewriting the agreement. I was fine with it. It changed absolutely nothing of substance. It was such a waste of time, a colossal waste of time and money for the client. But there it was. It was completely rewritten. Not one word left from the track change in the original draft. Okay, that's fine. Doesn't seem necessary. Don't use an aggressive tone. Again, tone matters. You have to model a collaborative tone. And of course, don't co-opt the process. This is not a negotiated settlement. This is a mediation. The clients chose this process.
Right. So are we ready to move on? We're going to talk about some nuts and bolts now, I think.
We can.
Okay.
Queued up.
Okay. So, we're trying to, I guess, Joe, are you going to go on and talk about this? I'm sorry.
I guess I am.
Yeah.
I queued myself up. Yes. So nuts and bolts. We talked a little bit about, review versus consulting. When are they calling us? Are they calling us with the draft in hand, or are they calling us because they're thinking about getting divorced? That'll tell you what kind of retainer you're going to send them. You're going to send them a review retainer. For a review, it's probably a few hours. A consulting retainer, could be anywhere between 5++, depending on how much hand-holding they need, where they're calling you in the process.
Right, and so the timing matters. That is what determines whether we're a review or consulting attorney. And I would recommend, if there's a choice, that you work with a consulting attorney earlier in the process, even before mediation starts. Some people call us then, but as I said, sometimes they come in later. And sometimes when they've had a couple of mediation sessions and then see a consulting attorney, they may be able to give more thought to what they've already said, some of the decisions they've already made, and they want to go back into the mediation room and change their mind and say they've changed their mind. And while I always say it isn't over till it's over, till the draft is signed, the other spouse might feel that there was a bit of a betrayal. You've broken your promise. I've already relied on the fact that the parenting time is going to be like this. Or I already thought the maintenance was going to be waived. So it is a lot harder when you're going back in later on and changing your mind than it is to come in kind of informed and ready to express yourself in mediation from jump.
Right. So we're sending them our retainer, whatever that might be. Catherine and my retainer are slightly different review versus consulting. How many hours? Both of them say that we will not participate in litigation. So if the mediation falls apart, if it becomes a collaborative, they can sign a new retainer with us if they so want. If it goes into litigation, we're withdrawing. It's also a limited representation retainer, which means a few things, but most importantly, we are not investigating the facts. We are not doing a full discovery like you would do if you were a traditional attorney. You are, again, supporting the mediation process. So that's there, that's disclosed in our retainer. The statement of client's rights and responsibilities, which should be attached to your retainer, that sets forth the various rights and responsibilities between the attorney and the client, has a whole slew of other things which we'll not get into, although we did make it available in the Google slide. One of them is the confidentiality of communications, client and attorney.
And we're happy to provide a copy, a template for anyone interested, either the retainer review or both. You can just reach out to us after the presentation. We're happy to share that. So in terms of figuring out how many hours to determine what's the range of hours, Joe mentioned between 3 and 5 hours. Something I'd like to bring up in the conversation with the client before I send the retainer in my initial phone call with them is, what's going on with their access to money? Some people have access to money now, they're still sharing a joint account or they have their own private money and they can give you the full amount that you both feel is going to be required, say the 5 hours. But some people really don't. They have very limited access to money now. They're going to need help speaking up about that and their budgets later on. And so it may be easier for them just to give on the lower end of the spectrum on that range and pay as they go. So I think it's something that some people don't even think about. They just give the number of hours that it would be required to get the job done, so to speak, but they wouldn't think about the other side of it, the client's side. That money, it's a lot of money. No matter what we charge per hour, and we have a range of hourly rates, it's a lot. It's expensive for clients, especially FamilyKind clients in particular. We're very sensitive to that. So now we've been retained. We've talked a lot about how we're going to be retained and what's the process going forward. So if we're working as a consulting attorney, again, there's a wide range. We may come in early or later, but any comments we have, we go through the client. We're not jumping into the process. We're on the sidelines, as Joe mentioned. So I would be helping the client understand what they want to say, how they want to say it, coach them on how to speak to their spouse or in mediation. But I'm not getting in the middle of that. If it's review, we have to be a little more obvious that we're there because we're now going to give comments and suggestions on that draft agreement. Some people like to do it in an email or a memo, even if they get the document in Word where they could write it right into the document. They like to do it in an email format or memo. So you really aren't seen in the document. Other people like to put it right in the draft as a comment along the sidelines. So I do it both ways. Sometimes I don't have the document in Word, and so I need to put it in a separate email or memo. And other times I can just put my language on the right-hand side. But again, the tone matters, the language matters, whether it's for the client or for ourselves. We're going to use language like, we propose that this be changed, or the client X prefers that this would be the case. We suggest further discussion on this topic. We're not here to mandate. Again, it's the client's process. We're advising them on the sidelines. And so I usually do my draft comments to the client. I go over it with the client in a phone call where we're both looking at it together. And sometimes the client says, take that out. I don't want to bring that up. That was very sensitive. That would be triggering. We want to make sure we're supporting their process. And so as long as I know that I've brought it up, I've discussed it with them, and they've decided not to go ahead with that comment, then that's okay. but I want to make sure that I do bring it up, and it's up to them to decide whether to go forward. Sometimes they'll speak privately to the spouse. Sometimes they'll bring it up in mediation later on.
Yeah, and I do, I have a similar process. I really try to work through the clients, not with the other consulting attorney as well. To wrap up the nuts and bolts, Catherine, what is your thoughts on filing uncontested papers for your consulting client or review client?
Typically, I'm not doing that. Typically, the mediator is filing it. Just like they finalize the agreement and they have the signing with the clients, they would go ahead and go on and do the filing. Often, I'm not consulted at that stage. There's nothing that they need help with. So once that agreement goes to signing, they kind of re-end my help with them, and they go on with the mediator to take it through to the drafting and filing. Sometimes, though, it's a non-attorney mediator and their scribing attorney doesn't get involved in that way. So they might ask if one of the consulting attorneys would mind, or which of the spouses is going to be the named plaintiff, even though they're consenting to do an uncontested filing. And then that person, that attorney might go ahead and file on behalf of the client. But it's with everyone's consent. It's everyone doing it together. It's not co-opting the process where all of a sudden I take the mediated agreement and go and file for divorce on my own with the other attorney. It still remains in the mediation process to the end. So you've heard that both Joe and I work as mediators as well as the consulting and review attorneys. And so we thought it might be helpful for some people to hear what it's like from the other side, so to speak. So now we switch, now we're the mediator, and now we want to involve the consulting and review attorneys in that process. So what does that look like for you, Joe? What's your practice?
Yeah, and again, among our peers and colleagues, there's a range. So Catherine and I, and we checked with Leslie, it's also FamilyKind's policy to strongly encourage consulting, at the very least review counsel. But I don't require it in all cases. So when would I require it? If there's red flags, for sure. There's a great power imbalance, an out-of-the-box, unusual agreement. Sometimes it's clear one or both parties need outside help. Maybe one of the parties is waiving an important right, whether it be maintenance or something very unusual with child support. Maybe one of the parties, in my mind, is not going to be self-sufficient. So they need a reality test with their own attorney. And of course, if they need further legal advice or explanation beyond what I can give them, so I would require it. It also makes the agreement stronger. So I tell them that too. If it is ever challenged, you hope it's not, but somewhere down the line, if one of the parties challenges the agreement, if there was an attorney review and there's court cases on this, if they had the opportunity at least to have a review, certainly if they had the review, it matters. It matters in terms of the way the court will look at that agreement.
I say the same, Joe, to my clients as well. But sometimes they really refuse. They just say, we came to mediation to avoid lawyers. Why do we need to have lawyers now involved in the process? Or I just can't afford it. I spent a lot already on the mediation, and now how can I afford for both of us to go and get counsel? What do you do in that situation?
Yeah, well, we've all been there. We chose mediation. Why do I need to spend more money? They really can't afford it, and I feel strongly that they should have a review. I will reach out to you, Catherine, or to one of our other colleagues and ask if someone can take this on a low bono, on a reduced fee. And I have never not been able to find someone, so thanks to all of you. It's a wonderful community. If they refuse, and there's no red flags, well, let's first do, if they refuse and there's red flags, I can terminate the mediation. If I'm really not comfortable going forward, I've done that a few times actually. It was just so outside the box, and whether there was not a disclosure, there was something that was so triggering for me that I terminated the mediation. I'm fine to do that. And the last thing, I'm going to,
What if they refuse? There's no red flag. It's okay. You know.
that's, yes, right here. So this is more often the case. There's no red flag and they refuse. This is when it becomes an optional. I will have the waiver language in the agreement, and it's quite strong. It looks like this. It's in bold. It's cannot be missed, and we review it. And sometimes it encourages them to get review, but it's there. It's in the agreement, and they had the opportunity at the very least.
And the last point is just to talk about providing what we call a mediation-friendly referral list. Attorneys that are going to support the mediation process. They don't have to be mediators themselves. You know, we have many people in our community that are not mediators, but they're wonderful consulting attorneys because they get it. They understand the compromises and cooperative spirit of mediation. So sometimes I send a full list of all my colleagues that I've worked with in the past, and sometimes more limited. Sometimes we might want to cherry pick a few, just depending on the client's circumstances and the situation. For example, if they might have a special needs child and they might need special counsel on trusts and estates or whatever it might be. So again, it depends. Like so many things we're talking about today, it just depends on the circumstances.
Yeah, so Patty, how do we do with time? We're at the end of the formal presentation.
Correct. So if you could advance to the next slide.
Yeah.
Some of the resources that you mentioned are in this Google Drive. People are also asking for your retainer that you had offered. So you may want to put that in this Google Drive.
Okay.
As well as a copy of the slides. So we can certainly do that. We are getting a lot of nice feedback and questions. I just wanted to invite Leslie to maybe, if you had any reactions to some of the things that were covered.
No, I thought it was great. I loved, hearing sort of about the nuts and bolts from two really expert review and consulting attorneys. So thank you, Joe and Catherine, for, sort of pointing these things out and, bringing up real things like expense and things like that. So we sort of do what mediators do at FamilyKind, and we give out a list of consulting and review attorneys. And I have to say that, Catherine, Joe, and many of our lawyer mediators do accept low bono sort of when they do review or consulting, because it's such it is sort of an important part of it, especially if there are red flags. Here I see our wonderful friend. Yes.
So I just wanted to say, I guess, as just the conclusion for us, for Joe and I, it's just to remember that you're here to be a gentle advocate for your client. You're still working as an attorney, so you're looking out for the client's best interest. But bearing in mind, when you do this work, we're all here together to work cooperatively to come up with an agreement that is durable, lasting for the family, and everyone feels was good enough for them to walk away. When they look back on their story, that the narrative will be one of respect and civility. And we're going to try to do our best to further that aim.
Yeah, I like those points that you are lawyers, no matter what. You're acting as a lawyer. However, you are on the sidelines and respectful of the mediation process and understanding it. So I love that. Who wanted to read this quote by RBG?
Joe?
Happy to. Reacting in anger or annoyance will not advance one's ability to persuade. How perfect is that?
Mm-hmm. Mm-hmm.
Yeah.
So we do have some questions coming in, and we have people asking for me to put the link for the Google Drive in the chat. Joe, I don't know if you're able to do that.
Oh,
All the
Patty, you're asking a lot. Let's
Okay,
see.
I'll do it. I'll ask you a question and then I'll do it.
We're lucky we got the PowerPoint shared. Okay.
So,
Patty, sorry, can I just add? Joe and Catherine, you're very, very generous to share all of this, which is great. And I just want to remind people that they can contact Catherine and Joe
Oh, of course.
said afterwards, just to really dig down maybe deeper into these issues.
Yeah, any questions, we're happy to answer on a phone call or by email.
great, great. So a few questions have come in and maybe you've covered them because I'm doing the whole span of the event, but I'll ask them anyway. So regarding legal review, who determines sufficiency? The client or attorney? Attorney informs of the rights of disclosure, but what if the client doesn't feel the need for disclosure, understands their right for disclosure, but doesn't want it? Who decides?
Right. I mean, I think we touched on that a little bit, that you must make full financial disclosure. You must. If you were in court, the court would require it. And so you're not in court. However, we're still here to be sure that everyone makes a knowing waiver. You can't waive something if you don't know what it is. And so everyone needs to disclose all their bank accounts, all their investment accounts, their true income, even if it's off the books income. You know, sometimes people don't report things on a tax return, but the spouse knows that there's other money. So we try to bring everything out. And so that is sometimes a reason that the mediation doesn't move forward. You know, even with the consulting attorney's help, they're trying to encourage that disclosure. They just don't want to do it. And that has been a reason why, as a mediator, I've seen those mediation fail. One person will not disclose, and they'll need to go to a more traditional process where they'll be compelled to, but they don't want to do it in the mediation process. Some people do look to the mediation process as a way not to disclose. They come to it specifically because they don't want to be forthcoming. But as Leslie points out, you know, we are attorneys here working, and so we need to stay with the legal construct. That's not really something that's optional. The disclosure is not really optional.
Okay. And then we have somebody asking about helping attorneys either not co-opt the process. And sometimes it may be inadvertent, and they were looking for some examples. For example, like if they start negotiating open items, that could be a way that the process maybe gets co-opted. I'm wondering if you could talk to that a little bit, or other examples.
Yeah, I mean, we've all been there. And I've been there from the mediator seat, and I've been there as the other consulting attorney. I think you're going to just encounter different styles along the way. You could only do what you can do in your own lane. I guess as the mediator, you might have, I'm curious, Catherine, if you have another thought on this, but I think the mediator, you can really control the process. As a consulting attorney, and if the other consulting attorney is a little more co-opting or aggressive, I think it's hard. It's a harder place to be. We've all been there.
Yeah, I have had situations where the other person was a more traditional family law attorney, and they immediately wanted to just have a conversation and start discussing the open issues. And I really just said, let's bring it back to the mediator. It's, if there's issues that haven't been resolved, let's bring it back to mediation. And the mediator was a colleague of mine, and so I was able to do an email to the other attorney and CC the mediators, so all of us were in this together, and we were able to come back and schedule another mediation session instead. But sometimes that's not possible. For example, if the mediator is a mental health professional and the issue is a legal issue, so I have a situation like that now. So sometimes the mediator prefers if the two attorneys talk a little bit, even have a four-way conversation with the clients. And it's very flexible. This whole process is very flexible, and it really depends so often on who's involved, what the clients want, what works best for the process for everyone. I don't think there's a clear answer, but I think there's techniques to bring to bear depending on the situation.
I would just like to add, yeah, I totally agree with that. Also, I think a point that's important to remember is not all lawyers are qualified to be review or consulting attorneys. So sometimes a matrimonial lawyer might say, I know all of this down. I know, I'm an expert in matrimonial law, but that doesn't mean that they're excellent at being a review and consulting attorney. So I think sometimes it happens where that overbearing, can come when someone doesn't sort of understand the process. So I'm glad that Catherine and Joe really helped us understand that there's a fine art to this.
Yeah, and Leslie, mediation training helps.
Mm-hmm.
And just some folks have different dispositions. So, right, traditional lawyers that have never taken a mediation training sometimes are perfectly appropriate in the process.
Mm-hmm.
Mediation training, I think, just fine tunes that
Mm-hmm.
asking the why.
Mm-hmm.
Certainly.
True. Right. Definitely. I'm not saying you have to have mediation training, but being sensitive to the whole process and understanding it. Sometimes a litigator understands their lane, so they can just do some extra work to learn about this process, maybe before jumping in as a review attorney.
So we've had a couple of questions come in on the process. I think you've covered some of this, but in case you wanted to add a little bit more detail, somebody is asking, does the consulting attorney typically attend the mediation session? And then the other question is it okay for the two attorneys to talk to each other outside of the mediator?
So I'll take the first question on that. So whether we attend or not. So you can, yes, the short answer is yes, you can attend. Whether or not that's the best idea, again, depends on the situation. Oftentimes, it can complicate it. However, the client doesn't realize that. The client will say, can you come with me? They're nervous. They don't feel confident. And then we talk further. What is it you need from me? And what is it you're looking to accomplish? And sometimes the attorneys in the room don't make it better because they can co-opt the process, because they can start talking to each other and the clients get lost. Especially on a Zoom, it's very challenging to have, say an attorney for each person, that's 4 people, plus you have the mediator, that's 5. Sometimes there's a financial advisor as well, or if it's a co-mediation, it's a lot of people. And I think the client, especially the client who's insecure, is going to be quiet and they're not going to speak up because they want the lawyer to speak for them. And now you've really changed the tone, the tenor of that meeting. And it's more like a settlement conference than a mediation. So I don't encourage it myself. I don't like to attend the sessions, and I don't like to have the lawyers come into my room. But there are other mediators very comfortable with it, working on court rosters where they're very comfortable with it and think it can be very helpful. So I'm just giving my opinion, but in short, yes, you can, but it's not always advisable. You have to be thoughtful about that.
And I have to restate that second part of the question. Can the consulting attorney reach out to the mediator privately with the client's permission?
So Joe, do you want to?
Yeah, I'm thinking that through. If the other party is represented, well, I guess I would say from the mediator's chair, they might not want to have ex parte communication, whether with the client or with the client and the attorney. So I guess that's where I'm actually thinking of it more from the mediator perspective. As the mediator, I wouldn't reach out necessarily to one party or one consulting attorney without the other. So probably from the flip side, if I'm the consulting attorney, would I reach out to the mediator? I guess I have done so. With my, if the client says, can you give my changes to the mediator, I've approved them. So I have, and then I guess it's the mediator's responsibility then to share those across to both parties.
And just a final question: when as the mediator, how are you ensuring full disclosure? Are you having the parties exchange SNW?
That is a wide range of answers to that question. I think there are many different practices. I think mediators have vastly different practices. I think for me, I have an asset and liability statement. I deliberately don't call it a sworn net worth statement. I don't have the clients sign it, swear to it, and notarize it like they would if they were in a court form. I know other mediators use that actual court form, so it's actually the form of disclosure. For me, I have the asset and liability statement. I do have them both fill them out. I do have them exchange it or bring it to the session depending on their level of conflict. Sometimes they cannot even email each other. Sometimes they don't even want to look at each other. They're just giving it to me. So I say, give it to me, and then I make sure we share it. I put it in my portal available to both clients. So that's how I do it.
Yeah,
Joe?
and I'm similar in that I don't call it a net worth statement. They're not swearing to it. They're not signing it. I call mine a financial information form. It's assets, debts, income, expenses, depending on what depth we need to go with the expenses. And, you know, if they're friendly and can work together, they often do it together. So I have it with 2 columns, spouse 1 and spouse 2. So I'm trying to make it mediation friendly. And sometimes they do it separately, as Catherine said.
And then we go over it together. And if I'm the mediator, we go over it together in the mediation room. And sometimes there are surprises. Some people, oh, I didn't know you had that account. And some people say, no surprises, I already knew all this.
Right. And it's for them. So if they're both in each other's finances, there should be no surprises. But sometimes there's a lack of trust, and you'd say, you know what, we actually need to see the account statements as of this date. So then they'll exchange those. But sometimes just having the account number, the balance is sufficient. So it depends, I think, on the parties and their level of trust.
Yes, absolutely.
And knowledge, right?
Yep, that's right.
Well, even though we added time to this, we've exceeded the time by a couple of minutes. So we had a lot of great questions. Hopefully I got to most of them. Apologies if I didn't. A couple of people wrote in how grateful they were to the information that you shared and for this topic. And even folks who are not attorneys, who are financial folks and mental health folks, they've said that this was really valuable to them as well. If you could advance the slide. What I would, and I guess this is your contact information. So again, I've put in the chat, the link to the Google Drive. I'll also put it in a follow-up email. Here is the contact information for Joe and for Catherine if you want to reach out to them privately. Again, getting more thank yous and great presentations from a lot of the people here today. And then if you could move to the last slide. So I want to, again, thank everybody for coming and for attending and sending in such great questions. I would like to thank Joe and Catherine for sharing their time and expertise with us today on this topic. Looks like we could go more on this topic, so maybe that'll be another future one. And I would like to thank also our sponsors, SoberLink and Our Family Wizard. Without them, we would not be able to put on this this webinar series. And as most of you know, FamilyKind is a nonprofit, and we do rely on the help of not only sponsors, but the donations of family and professionals. If you feel so inclined to support FamilyKind, there's a link here, familykind.org/help-FamilyKind for donation information. Our next peer-to-peer webinar will be on Monday, October 19th. And we look forward to seeing you then. And as always, if you have any comments or questions or suggestions for future topics we should address on the peer-to-peer series, please feel free to reach out to me at communications@familykind.org. Thank you, everybody, and have a great day.
Thank you. Thank you all. Thanks, Patty, Joe, and Catherine, too.
Thank you. Thank you.
Take care. Be well.